What are fixtures? Fixtures are personal channels affixed to real estate which may be severed and removed by the party who has affixed them or by his personal representative against the will of the owner of the freehold. Questions frequently arise as to whether given appendages to a house or land are to be considered part of the real estate, or whether they are to be treated as personal property. The latter are movable, the former not. The annexation may be actual or constructive. By actual annexation, it is understood that every mode by which a chattel can be joined or united to the freehold. The article must not merely be laid upon the ground, it must be fastened, fixed, or set into the land or into some erection, as is unquestionably a part of the realty. Otherwise, it is in no sense a fixture. Locks, iron stoves set in brickwork, posts, and window blinds afford examples of actual annexation. Some things, however, have been held to be a parcel of the realty, which are not annexed or fastened to it. For example, deeds or chattels which relate to the title on the inheritance and go to the heir. But loose movable machinery used in prosecuting any business to which the freehold is adapted cannot be considered part of the real estate, nor in any way pertinent to it. So deer in a park, fish in a pond, and doves in a dove house go to the heir and not to the executor, being like keys and heirlooms constructively annexed to the inheritance. The general rule is that fixtures once annexed to the freehold become part of the realty. But this rule, there are exceptions, as first, where there is a manifest intention to use the fixture in some employment distinct from that of the occupant of the real estate. Second, where it has been annexed merely for the purpose of carrying on a trade. For the fact that it was put up for such a purpose indicates an intention that the thing should not become part of the freehold. But if there is a clear intention that the thing should be permanently annexed to the realty, its being used for the purposes of trade would not, perhaps, bring the case within one of the exceptions. With respect to the different classes of persons who claim the right to remove a fixture, it has been held that where the question arises between an executor and the heir at law, the rule is strict that whatever belongs to the estate to which the fixture appertains will go to the heir. But if the ancestor manifested an intention, which it is said may be inferred from the circumstances, that the things affixed should be considered personality, they will be so treated and will go to the executor. As between a vendor and a vendee, the same strictness applies as between an executor and an heir at law. For all fixtures which belong to the premises at the time of the sale, or which have been erected by the vendor, whether for purposes of trade or manufacture or not, as potash kettles for manufacturing ashes and the like, pass to the vendee of the land unless they have been expressly reserved by terms of contract. The same rule applies as between mortgager and mortgagee, and as between a devisee and the executor. Things permanently annexed to the realty at the time of the testator's death pass to the devisee, his right to fixtures being similar to that of a vendor. But as between a landlord and his tenant, the strictness of the ancient rule has been much relaxed. The rule here is understood to be that a tenant, whether for life, for years, or at will, may sever at any time before the expiration of his tenancy, and carry away all such fixtures of a chattel nature as he has himself erected upon the demised premises for the purposes of ornament, domestic convenience, or to carry on trade, provided always that the removal can be effected without material injury to the freehold. There have been adjudications to this effect with respect to bakers' ovens, salt pans, card machines, cider mills and furnaces, steam engines, soap boiler vats, and copper stills, millstones, Dutch barns, standing on a foundation of brickwork set into the ground, a varnish house built upon a similar foundation with a chimney, and to a ballroom erected by the lessee of an inn resting upon stone posts slightly embedded in the soil. and also in regard to things ornamental or for domestic convenience, as furnaces, stoves, cupboards, and shelves, bells and bell pulls, gas fixtures, pier and chimney glass, although attached to the wall with screws, marble chimney pieces, grates, window blinds, and curtains. The decisions, however, are adverse to removal of hearthstones, doors, windows, locks, and keys, because such things are peculiarly adapted to the house in which they are fixed. Also, to all such substantial additionals to the premises as conservatories, greenhouses, stables, pigsties, and other outhouses, shrubbery and flowers grown in a garden, nor has a privilege been executed to erections for agricultural purposes, though it is difficult to perceive why such fixtures should stand upon a less favored basis than trade fixtures, when the relative importance of the two is considered. The time for exercising the right of removal is a matter of much and some importance. A tenant for years may remove at any time before he gives up possession of the premises, although it may be after his term has expired and he is holding over. But tenants for life or at will have uncertain interests in the land, have, after their determination of their estates not occasioned by their own fault, a reasonable time within which to remove their fixtures. If a tenant quiet possession of the land without removing such fixtures as he is entitled to, the property in them immediately vests to the landlord, and though they are subsequently severed, the tenant's rights to them does not revive. If therefore a tenant desires to have any such things upon the premises after the expiration of his term, for the purposes of valuing them to an incoming tenant or the like, he should take care to get the landlord's consent. Otherwise, he will lose his property in them entirely. The rights of parties with respect to particular articles are sometimes regulated by local customs, especially as between outgoing and incoming tenants, and in cases of this kind it becomes a proper criterion by which to determine the character of the article and whether it is a fixture or not.